The following BLTV program.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about what is needed for a contract to be legally binding. This is generally the same across all states. So first, let's talk about the elements of a valid contract. These are offer, acceptance, and consideration. And we're going to dig in a little bit to what these each mean. So offer and acceptance kind of go together as one unit. An offer is someone agreeing to do something or not do something in exchange for another party doing something or not doing something. So an offer has to be extended from one party to the other. The other party has to accept that offer in its exact terms before the offer is withdrawn. So timing is important. If the offer is extended and then withdrawn before the other party says I accept, then you don't have a contract. Another issue is the difference between acceptance and a counteroffer. So if the party that is purporting to accept the offer basically adds terms or changes the terms of the offer, they say, I accept, but I want to change this part of your offer, or but you have to do this additional thing, that's not acceptance, that's a counteroffer. And the other party then has to accept the counteroffer. The original offerer has to accept the counterofferer's counteroffer before you have a valid contract. So saying, yes, I accept, but I want to add this does not create a contract. You have to accept the exact terms of the offer before the offer is withdrawn. So that's offer and acceptance. What's consideration? Consideration is basically value exchanged by both sides in the contract. So both parties have to be receiving some new value that they weren't going to get before they entered this contract. So what does that mean? That means it's a distinction between a contract and a gift. I can't say, I promise to give you $15 and you don't have to do anything for it and call that a contract. That's a gift. That's not legally binding. I don't have to give you the $15. Instead, I need to say, I promise to give you $15 in exchange for you promising to shovel my driveway. Now we have a contract and both parties are obligated. A key to consideration is that it has to be some new consideration. It has to be something that the party offering to do it wasn't originally legally obligated to do or not do. So it's got to be, you have to be getting some new value from the contract, and both sides have to be getting value. So you need offer, acceptance, and an exchange of consideration. There are also some technical requirements to formation of a contract. So these are kind of prerequisites before we even get to whether the parties did the things necessary in the contract itself to make a valid contract. These are that both parties have to be at least 18 years old. If one of the parties is a minor, you can still have a contract, but the minor has the option to back out of the contract. The minor can, however, hold the adult liable for performance of the contract. Both parties have to be of sound mind. And both parties have to have the legal power necessary to enter into the contract. So when we're doing this, we're talking about agents or guardians, people who work for other people. The person who they're contracting for has to at least given the other side of the contract reason to believe that this person has the power to contract. So someone can't go out for O'Flaherty Law who has no affiliation with O'Flaherty Law and who I've never said works for O'Flaherty Law and bind me to a contract with somebody else. So in addition, a layer on top of this, we've talked about kind of the technical prerequisites, the actual offer, acceptance, and consideration, the elements of creation of the contract, assuming those prerequisites exist. A couple other things to be aware of. One is that there are a lot of specific state and federal statutes out there that affect ability of parties to contract in specific industries. So they might require certain notices to be given by the more sophisticated party that works in the industry in order to make the contract valid, or they might say these specific types of contracts are just invalid. So the contract has to be legal, it has to be not in violation of one of these statutes, it has to comply with any industry-specific statutes. Either party may have a defense to breach of the contract. And in these cases, the contract is valid, but it's really unenforceable if the party can raise a defense. So defenses are things like the contract was executed under duress, the proverbial gun to my head. There was a mutual mistake of fact, so both parties thought that they were contracting to purchase the Maltese Falcon when it turned out it wasn't the actual Maltese Falcon, and they find out after the fact. Then that can be a defense to performance. Fraud And there's several other defenses that we talk about in our video and article on the subject of contract defenses. We're not going to go into too much detail. But you want to have the technical prerequisites, the elements, offer acceptance consideration, make sure you're on top of any state and local statutes that are industry specific, and no valid defenses, and you have a breach of contract. A lot of people, I'm sorry, you don't have a breach of contract, you have an enforceable contract. A lot of people ask whether a contract has to be in writing to be valid. It does not generally have to be in writing. An oral contract is valid as long as it meets all of these elements. Now, there is something called the statute of frauds that says certain types of contracts have to be in writing, and there's a list of about 10 different types of contracts. One of them is for the exchange of real estate, and this is for the purpose of preventing people claiming to have a contract when they don't really in specific types of situations. So certain types of super important contracts have to be in writing, but the general rule is that contracts can be oral and still be valid. The problem is with an oral contract, you have a lot of trouble, A, proving that a contract exists, and B, proving what the terms of that contract are. So you have to go based on circumstantial evidence, the person's actions in accepting goods that were exchanged as part of the contract. Oral contracts are very, very tricky to enforce because of the element of proof, not necessarily because of their lack of legal validity. Finally, let's talk about letters of intent and non-enforceable contracts. So a letter of intent is something that parties who are about to agree to a somewhat complex contract sign. It's not actually a contract, though, generally. What it is a statement of a bullet point statement of what the general terms that they have a meeting of the minds are, and an agreement to negotiate the finer details and the legalese based off of these terms. So it's just a starting point before people hire a lawyer or before they spend much money on a lawyer. They want to make sure that they agree to all the basic terms, the substantive terms of their agreement, and that's what a letter of intent is. And usually it's not enforceable unless there's specific language on the letter of intent that says this is an actual contract, or if either party backs out of this letter of intent, they're going to agree to pay $5,000 to the other side. The reason it's not enforceable is because usually all of the terms aren't fleshed out. This is just a meeting of the minds on what the general terms of the contract will ultimately be once each party has had a chance to negotiate with the help of an attorney. So it's an agreement to work towards a contract, but not a formal contract, typically not enforceable. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com, or in the comment section below our YouTube video on our YouTube station. We post new articles and videos every day, so a new video and article every day. So if you want to be informed of what the content is, which articles we're posting that day, feel free to subscribe to us on YouTube, iTunes, and SoundCloud. If you need some help, feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in several areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.